Okay, imagine this. You've got a university, right? A big one, Harvard. And they've had this relationship with the U.S. government for like 70 plus years, letting international students study there.
A really long-standing thing. Decades.
Exactly. And then, boom, suddenly the government says, nope, you can't host these students anymore. Not because of some obvious failure. It just seems to happen overnight.
And it gets even more complicated. The government apparently tied billions, with a B, billions in federal funding, to these huge demands for changes inside Harvard.
Yeah, we're not talking small tweaks. The sources mention things like telling them who to admit, who to hire, even which student groups need to be shut down.
It sounds pretty wild, but that's exactly what's at the core of this legal fight that just blew up. Harvard is now suing the U.S. government, saying this is precisely what went down.
Right, and that's our focus for this deep dive. We've got the court documents, Harvard's actual complaint filed in federal court, plus news reports covering it, and even some social media posts from people right in the middle of it all.
Yeah, our goal here isn't just to skim the headlines. We really want to unpack what Harvard is claiming in their lawsuit, understand the government side of things, or at least their actions as described in these sources, and figure out what this all means, especially for the thousands of students who are directly impacted.
Okay, let's get into it. So first up, we need to kind of set the scene. What does the international student situation usually look like at Harvard? Because this isn't just a minor program for them.
No, not at all. It's massive and, like you said, decades old. Over 70 years of history here.
So integral to the university.
Absolutely. The sources show Harvard brings in international students mainly through two big government programs. There's the F1 visa that's run through the Student and Exchange Visitor Program, SEVP. Think of that as the main one for regular degree students.
Right, SEVP. And that's under DHS, Homeland Security.
Correct. And then there's the J1 visa program, which is more for exchange visitors, researchers, scholars. That one falls under the Department of State.
Got it. And the scale here is pretty significant, isn't it?
Oh, definitely. The complaint says over 5,000 enrolled students are on F1 visas. That's more than a quarter, like 26% of Harvard's whole student body. And they come from all over, 143 countries mentioned.
Wow, 26%. That's huge.
And that's not even everyone. You've got maybe another 2,000 F1 students doing postgrad work, OPT, or STEM OPT it's called, plus several hundred J1 visa holders. If you add in international scholars, too, we're talking well over 10,000 people whose ability to be here is tied to these government certifications.
And these aren't just numbers. The sources stress how much these students contribute, right?
Yeah, the complaint really emphasizes their value, describes them as vital not just to Harvard, but to the U.S. more broadly. They enrich campus life, obviously, culturally and academically. They're involved in cutting-edge research. Sometimes they teach courses. They drive innovation, start businesses. It's a long list of contributions.
So, okay, how does a university like Harvard get permission for this in the first place? What's the normal drill?
It's a pretty standard government process, actually. SEVP certification, schools apply. They have to show they're a real school, have the right facilities, staff, the basics.
Makes sense.
And crucially, they have to agree to follow specific rules about keeping records on students and reporting certain information to the government. Then they just need to renew this certification every 2 years.
And Harvard says they've always done this?
According to the complaint, yes. For over 70 years, they've met all the requirements, kept up the record keeping, and renewed their certification without any problems. Just routine renewals.
Okay, so 70 years of, let's say, smooth sailing. What suddenly changed? How do we get to this point?
Right. This is where things take a really sharp turn. The complaint and the news reports describe this buildup, escalating demands from the government before they pulled the plug on the visa programs.
And it seems to kick off with a specific letter, April 11th, 2025.
That's the date mentioned in the complaint. A letter sent directly to Harvard's president and the Harvard Corporation leaders.
Not just some low-level request, then.
No, it came from a multi-agency federal task force, which suggests, a coordinated government effort. And this letter, as Harvard describes it, laid out a whole bunch of conditions. Things the government said were necessary for Harvard to implement if it wanted to keep getting federal money.
And we're talking serious money.
Billions. The complaint mentions over $2.2 billion in existing federal funding was potentially on the line.
Okay, so what were these conditions? Were they related to the student visa programs?
Not directly, not at first. They were much, much broader.
Yeah.
Really striking at how the university operates internally.
Like what? Give us some examples from the sources.
Okay, well, the complaint lists things like demanding audits of viewpoint diversity. for literally everyone, students, faculty, staff, leadership in every single department.
Viewpoint diversity audits. What does that even mean in practice?
That's a good question. The letter apparently didn't just stop there. Based on these audits, Harvard was then supposed to hire and admit a critical mass of people to fix whatever viewpoint imbalances the government perceived.
So dictating hiring and admissions based on viewpoint.
That seems to be the implication Harvard drew. It also demanded that Harvard refuse admission to international students that the government decided were hostile to American values.
Who defines hostile, I wonder? And did it go further into things like faculty?
Oh, yeah. Demanded the government get to review faculty hires.
The government reviewing Harvard faculty hires.
That's what's alleged.
Yeah.
And then specific actions against students and groups. Demands to expel or suspend particular students. Demands to disband certain student clubs, and they actually named names.
Which ones?
Groups like the Harvard-Palestine Solidarity Committee, Students for Justice in Palestine. The letter apparently listed them specifically.
Wow. That's specific. Anything else that jumps out?
Yeah, something really unusual, demanding Harvard set up systems for people on campus to basically report on each other, and those reports would be sent straight to the government.
Reporting mechanisms feeding info to the government? That sounds chilling.
It's quite a demand. And there was more. Reforming university governance to empower people most devoted to these government-mandated changes while weakening the power of students, junior faculty, anyone seen as committed to activism.
So restructuring the internal power dynamics.
Seems like it. Plus, eliminating diversity, equity, and inclusion DEI programs entirely. Reforming student discipline to be quicker, more transparent, impartial. Using police intervention if needed to stop disruptions. And, almost randomly, implementing a comprehensive mask ban.
A mask ban. That seems out of place with the rest.
It does feel tacked on, but it was reportedly in there with all the other demands.
Okay, so Harvard gets this letter with this incredibly long and intrusive list of demands tied to billions in funding. How did they respond?
They didn't wait long. According to the sources, on April 14th, just 3 days later, Harvard President Garber sent back a letter. And it was a firm
Just refused.
Flat out refused. The complaint quotes him saying things like, "No government should dictate what private universities can teach, whom they can admit and hire." He called the demands unprecedented government regulation of the intellectual conditions. Harvard's lawyers apparently also chimed in, saying they wouldn't let the federal government take over the university.
Strong words. And what was the government's reaction to that refusal?
According to Harvard, swift and harsh. Retribution, they call it. The very same day they sent the refusal, April 14th, the government froze that $2.2 billion plus in federal funding.
The same day.
That's the timeline laid out in the complaint. Hours after the refusal, the funding was frozen.
Now, around this time, there were also some very public comments being made, particularly by former President Trump.
Yes, the complaint points to his social media activity, posts on April 15th and 16th. He linked Harvard's problems to its tax-exempt status, called it an anti-Semitic, far-left institution, accused it of teaching hate and stupidity, talked about radical ideology, leftist dopers.
Pretty strong language.
And then later, there's mention of an April 24th transcript where he apparently talked about pulling grants until Harvard handed over lists of students involved in criminal activity. Harvard uses these public statements in its lawsuit as evidence suggesting the government's actions were retaliatory and based on disapproval of Harvard's perceived ideology.
Okay, so we have these broad demands. Harvard says no. The funding gets frozen almost immediately, and there's this heated public rhetoric. How did things then escalate to actually revoking the SEVP and J1 certifications?
Well, the government didn't stop there. Just 2 days after freezing the funds on April 16th, the complaint states that DHS Secretary Kristi Noem sent a formal records request to Harvard's international office, the HIO.
Okay, so now the focus shifts specifically to the international students.
Exactly. This request reportedly started by criticizing Harvard for, quote, failing to condemn anti-Semitism, and then demanded a huge amount of information on each student visa holder, F1 and J1, across all of Harvard's 13 schools.
All of them. And was the deadline reasonable?
Not according to Harvard. They were given just 10 business days. Deadline April 30th.
And what kind of information were they asking for? Was it the standard stuff?
This is a really key point in Harvard's legal argument. They say much of what was demanded goes way beyond what the standard SEVP regulations actually require schools to keep track of or report.
Like what, for instance?
The request asked for info on things like any known illegal, dangerous, or violent activity by visa holders, any threats they made, any actions depriving others of their rights, anything obstructing the learning environment, and details of any disciplinary actions related to protests that affected a student's immigration status.
That sounds very broad and subjective. What are schools normally required to track?
Harvard points out the regulations focus on more objective data. Contact info, their major, coursework, start-10 dates, and specific academic status changes like being suspended or dismissed. Not this kind of broad conduct monitoring unless it actually resulted in one of those formal status changes defined by the rules.
So a much wider net of information being demanded. And did this request also come with a threat, like the first letter?
It did, a very specific one. The letter apparently stated that if Harvard didn't provide everything requested by April 30th, DHS would treat it as Harvard voluntarily withdrawing from the SEVP program.
Voluntarily withdrawing, but they weren't withdrawing.
Exactly. And crucially, this forced voluntary withdrawal would, according to the letter, not be subject to appeal. Basically, comply fully or you're out and you can't fight it.
Wow. And was this request kept quiet?
No, there was a press release about it the same day, April 16th. It called the letter scathing, and again explicitly linked the demand for records to Harvard's alleged radical ideology and pro-Hamas ideology.
Okay, so Harvard's facing this massive demand for information, much of which they say they aren't required to have, under threat of immediate, non-appealable termination. What did they do?
They tried to comply, according to the complaint, but within the limits of what they were legally required to maintain and what they could reasonably gather in just 10 days.
So what did they provide by the deadline?
By April 30th, they produced, quote, thousands of data points, basically. The information they are required to track under the normal SEVP rules for their visa students.
Did the government accept that?
Apparently not entirely. There was some back and forth. On May 14th, following up on a May 7th email from DHS, Harvard provided some additional info. They also stated that, looking through their records for the kind of disciplinary actions DHS seemed interested in, they found only 3 students whose actions had actually resulted in a formal change to their academic status that would need reporting under the regulations. They also asked for clarification on some of the vague terms in the original request, like obstructing the learning environment.
Okay, so Harvard provided what they were required to, explain the limits, and ask for clarity. What happened next?
On May 22nd, DHS dropped the hammer. They sent a notice summarily revoking Harvard's SEVP certification, effective immediately.
Immediately. And what reason did they give? Did they say why Harvard's response was insufficient?
The complaint says DHS deemed the responses insufficient, but without explaining how they were insufficient or pointing to any specific regulation Harvard had actually violated. It was very summary.
So what did the revocation notice actually cite as the reason?
According to the sources describing the notice, it gave 2 main reasons. First, Harvard's supposed refusal to fully comply with the records requests. And second, this broader accusation. Perpetuating an unsafe campus environment that is hostile to Jewish students, promotes pro-Hamas sympathies, and employs racist diversity, equity, and inclusion policies.
So mixing the records request with these much broader, politically charged accusations about the campus environment and DEI?
Exactly, linking the procedural issue with these ideological judgments.
And they revoked it immediately, but then offered a way back. That seems odd.
It is strange. The notice apparently offered Harvard a chance to get its certification back, but only if it provided even more information, including disciplinary records and protest footage going back 5 years within just 72 hours. So an even broader demand, an even tighter deadline.
And I bet there was another press release.
You bet. May 22nd, the day of the revocation. Another press release, again using very strong language. It linked the revocation to pro-terrorist conduct and a toxic campus climate. It repeated allegations about coordination with the Chinese Communist Party. And it explicitly connected this action to the earlier freezing of DHS grants, tying it all together.
Okay, now let's get to a really critical part of Harvard's lawsuit, the process. They argue the government didn't follow its own rules for doing this.
This is absolutely central. It's a major pillar of their case based on administrative law. The government actually has very specific regulations spelling out how DHS is supposed to withdraw a school's SEVP certification.
And what do those rules require?
Well, first, DHS is supposed to issue something called a Notice of Intent to Withdraw, or NOIW. This notice has to clearly state the specific reasons why they think the school should lose its certification, which regulations they violated, what the evidence is.
Okay, so specific charges. Then what?
Then, the school gets a guaranteed 30 days to respond. They can submit evidence, sworn statements, arguments against the withdrawal. They also have the option of a telephone interview with DHS officials to discuss the case, and they have the right to be represented by a lawyer throughout this.
So a chance to defend themselves against specific allegations.
Exactly. And if, after all that, DHS still decides to withdraw the certification, they have to issue a formal written decision explaining the specific reasons for that decision. And even then, the school has the right to file an administrative appeal within DHS itself.
A multi-step process with clear rights for the school.
Absolutely. Built-in checks and balances.
And Harvard's lawsuit claims none of this happened.
That's precisely their claim. They allege DHS just completely ignored this entire mandatory process. No NOIW detailing specific regulatory violations, no 30-day response period, no chance for an interview, no detailed written decision explaining the rationale, and no opportunity for administrative appeal before the revocation took effect. Just summary revocation, effective immediately.
And does the same apply to the J-1 program revocation?
Yes, the sources indicate there's a similar regulatory process for revoking a J-1 program designation, also requiring things like 30 days notice, specific grounds, and a chance for the school to oppose it. Harvard alleges those procedures were ignored too.
Has this ever happened before, a school losing certification this way?
According to a statement in the complaint, based on Harvard's information and belief, no school has ever had its SEVP certification revoked for reasons other than failing the basic eligibility requirements, like not being a real school or failing to meet the standard, specific record-keeping and reporting rules clearly listed in the regulations.
So using these broader, vaguer reasons like unsafe environment or pro-Hamas sympathies as the basis for revocation and doing it summarily, that seems unprecedented according to Harvard.
It certainly appears to be a major deviation from the established norms and procedures based on how Harvard presents the case. It bypasses all the usual safeguards meant to ensure fairness and prevent arbitrary action.
Okay, let's talk about the impact. What happens when a university's SEVP and J-1 certifications are suddenly revoked like this? What are the real-world consequences described in the complaint and news reports?
The sources describe the consequences as immediate, severe, and frankly, devastating, both for Harvard as an institution and especially for the thousands of students.
Let's start with Harvard. What's the damage to the university itself?
Well, right away, they lose the ability to issue new I-20 forms. The I-20 is that essential document international students need to apply for their visas and legally enter or stay in the U.S. to study.
So no new international students can come?
Essentially, yes. It blocks the pipeline for future international enrollment. The complaint also talks about the huge investment Harvard has made over many decades in building these international programs and supporting the Harvard International Office. They mention an annual budget over $3.4 million, a staff of 25 people. All that effort is suddenly undermined.
And reputational.
Big hit. It damages Harvard's standing globally, makes it way harder to attract top international students and faculty in the future.
Okay, that's the institutional impact. But what about the students? The over 7,000 current F1 and J1 visa holders. This sounds terrifying for them.
It is. This is where you see the most profound human cost described in the sources. For these students, the revocation means they risk losing their lawful immigration status in the United States, like immediately.
Losing their status. What does that lead to?
It could mean facing removal proceedings, deportation, and potentially being barred from re-entering the U.S. for 3 years or even longer.
So their lives are just thrown into chaos. What options do they even have?
Very few, and they're incredibly difficult. The sources say they basically have two choices. Either find another SEVP-certified school that will accept them for a transfer and do it almost instantly.
Which must be nearly impossible for thousands of students all at once, right? Especially mid-semester.
Exactly. Logistically, it's a nightmare. The other option is to just depart the United States, leave the country.
Just pack up and leave. Mid-degree.
Yes. It completely blows up their studies, derails their plans to graduate, messes up their academic and career paths. Think about students relying on work authorization like OPT or CBT, tied to their student status that's gone too. It forces them, and often their families, who might have made huge sacrifices, to just abruptly abandon everything here.
And normally, isn't there some kind of grace period if a school loses certification?
Usually, yes. The termination of their SEVS access, which is what triggers the loss of status, is often delayed while administrative appeals are happening. But here, because the revocation was declared effective immediately, That cushion disappeared. It created this intense, immediate pressure and uncertainty.
Okay, so faced with this drastic situation, the immediate revocation, the alleged lack of process, the devastating impact, Harvard obviously decided to fight back legally.
They did, very quickly. The day after the revocation notice, May 23rd, Harvard filed this lawsuit in federal court.
Who are they suing exactly?
The lawsuit names the Department of Homeland Security, DHS, the Department of Justice, DOJ, the Department of State, and several specific officials allegedly involved, including DHS Secretary Kristi Noem, and, interestingly, individuals like Florida Attorney General Pamela Bondi and Senator Marco Rubio are also named as defendants associated with the federal task force.
And the lawsuit lays out their legal arguments for why the government's actions were illegal. Let's walk through the main ones, maybe starting with the First Amendment arguments.
Yeah, they make several First Amendment claims. The first one is retaliation. Harvard argues the government punished them specifically for exercising their constitutional rights, their right to refuse the demands in that April 11th letter, and their right to academic freedom.
And how do they support that claim?
They point to the timing as strong evidence. The funding freeze happening just hours after their refusal letter. The records request coming just days later. And they highlight the government's own public statements and press releases and the revocation notice itself, which explicitly link the government's actions to things like Harvard's perceived pro-Hamas sympathies or toxic campus climate. They argue this shows the government's motive was to punish them for their speech or perceived viewpoints.
Okay, retaliation. What else under the First Amendment?
Viewpoint discrimination. This is the argument that the government was trying to regulate or penalize Harvard based on the government's disagreement with Harvard's perceived ideology or the viewpoints expressed on campus. They argue the government was trying to force Harvard to adopt the government's preferred message and even tried to manipulate the makeup of the university community based on viewpoint through those earlier demands. That, they say, is unconstitutional.
Makes sense. And there was a third First Amendment argument, something about an unconstitutional condition.
Yes. This is a really important legal concept. The argument is that the government was conditioning a valuable benefit in this case, the SEVP and J1 certifications that allowed them to host international students on Harvard, giving up its constitutional rights, like academic freedom and freedom of speech.
So, do what we say, adopt our views, or lose this crucial program.
Pretty much. Harvard argues this is illegal based on established case law. The government generally can't force you to surrender your constitutional rights as the price for receiving a government benefit, even if you don't have an absolute entitlement to that benefit in the first place. Refusing the government's demands, Harvard argues, was constitutionally protected activity, and revoking the certification was the illegal penalty for that refusal.
Okay, those are the constitutional arguments, but they also heavily relied on administrative law, right? The Administrative Procedure Act, the APA.
Absolutely. This is where all the arguments about the government skipping the proper procedures come into play. Under the APA, they argue the government's revocation was, first, contrary to law and involved failed procedure.
Because they didn't follow their own rules.
Exactly. They point directly to those mandatory steps in the SEVP withdrawal regulations. We discussed the notice of intent, the 30-day response period, the need for specific reasons in writing, the appeal process. Harvard alleges DHS just tossed those rules aside, making the summary revocation illegal under the APA's requirement that agencies follow their own procedures. They make a similar argument for the J1 revocation process being ignored too.
Is there another APA angle they take, something about licenses?
Yes, they cite a specific part of the APA, Section 558C, which deals with revoking licenses. They argue the SEVP certification functions like a license. This section generally requires an agency to give the licensee notice of the specific facts that warrant revocation and, crucially, an opportunity to achieve compliance, basically, fix the problem before the agency starts formal proceedings to take the license away.
And Harvard says they didn't get that chance.
Right. They argue DHS never gave them specific notice of any actual regulatory non-compliance they needed to fix, and certainly no chance to fix it before hitting them with the immediate revocation.
And the final big APA argument is that the whole decision was arbitrary and capricious. What does that mean?
It's a key standard under the APA. It basically means the agency's decision was unreasonable, wasn't based on a consideration of the relevant factors, or lacked a rational connection between the facts found and the choice made.
How does Harvard argue the revocation was arbitrary and capricious?
They argue it lacked a reasoned explanation. DHS didn't explain why their response was insufficient. They say it wasn't supported by evidence, especially since it seemed based on Harvard failing to provide information that wasn't even required by the regulations in the first place. They argue the punishment yanking the certification for thousands of students was wildly disproportionate to any alleged failure to provide some data points. And, crucially, they argue DHS completely failed to consider the massive, devastating impact this decision would have on the university, and more importantly, on the thousands of students whose lives depend on this certification, what lawyers call reliance interests. They also point to the unexplained departure from established procedures as evidence of arbitrary action.
Okay, one more legal angle. The Constitution's Due Process Clause.
Right, the Fifth Amendment. Here, Harvard argues that having the SEP certification is a protected property interest. It's valuable, they rely on it, and the government can't deprive them of that property without due process of law.
Which means
Fair procedures. Specifically, fair notice of what they supposedly did wrong and a meaningful opportunity to be heard to defend themselves before the deprivation happens. Harvard argues they got neither. The government's demands were vague. The revocation notice didn't clearly state which specific regulation they allegedly violated, so they didn't have fair notice. And the summary revocation obviously denied them a meaningful chance to be heard beforehand.
so a multi-pronged legal attack. Retaliation, viewpoint discrimination, unconstitutional condition, failure to follow procedures, arbitrary action, lack of due process. What happened when Harvard took these arguments to court?
Well, the court responded incredibly quickly. The same day Harvard filed the lawsuit, May 23rd, a federal judge, U.S. District Judge Allison Burroughs, granted Harvard's request for a temporary restraining order, a TRO.
A TRO. What does that do, practically speaking?
It's basically the court hitting the pause button.
Yeah.
The TRO temporarily stops DHS from actually enforcing the SEVP certification revocation. It means Harvard can, for now, continue operating its international student programs.
And did it address that 72-hour deadline for more documents?
Yes. Importantly, the TRO also specifically blocked DHS from requiring Harvard to turn over those additional broad categories of documents and protest footage that the government demanded in the revocation notice within that tight 72-hour window.
So immediate relief for Harvard and its students, but temporary.
Exactly. It prevents the immediate chaos, but it's just a short-term fix.
Yeah.
The judge needs to hear more from both sides.
What happens next in the court case?
Things are moving fast. A status hearing was scheduled for May 27th to figure out the next steps, and then a really crucial hearing is set for May 29th. That hearing will be on Harvard's request for a preliminary injunction.
And a preliminary injunction would be longer lasting than the TRO.
Yes. If granted, it would likely keep the pause button pressed, keep the revocation blocked for a much longer period, potentially while the entire lawsuit plays out, which could take months or even years. So that May 29th hearing is a big deal. Harvard will need to convince the judge they're likely to succeed on the merits of their case and that they'll suffer irreparable harm if the injunction isn't granted.
Now, you mentioned news reports quoting legal experts. What's their take on Harvard's chances here?
The experts cited in the sources we looked at seem pretty optimistic about Harvard's case. People like Stephen Yale Lower, who's a well-known immigration law professor, Eric Friedman, Norm Eisen, Darren Hutchinson, they generally predict Harvard has strong arguments and is likely to win, both on the procedural grounds and the constitutional claims.
Why are they so confident?
They basically echo Harvard's arguments. They describe the government's actions, as alleged, as likely violating the Constitution, federal statutes like the APA, and the government's own regulations. They use terms like arbitrary and capricious.
And they emphasize the importance of following the rules.
Yes, exactly. One expert quoted called the procedural rules a product feature, not a bug, of our legal system, meaning these processes exist for a reason. They protect against rash decisions and government actions based on, quote, passing political whims. They see this case as potentially a textbook example of why those procedural safeguards matter.
The sources also put this specific action against Harvard into a slightly wider context, don't they?
They do. Some reports mention this isn't happening in a vacuum. They note the other pressures on Harvard, like the funding cuts and the threats regarding its tax-exempt status. And they mention that the Trump administration has reportedly targeted international students and visa holders more broadly in other situations, sometimes revoking visas with little explanation. There's even a mention of a recent court case where a judge blocked a different administration policy that would have terminated the status of many international students nationwide.
And just to add one more piece of context, the economic side of international students in the U.S.
Right, it's significant. The sources cite data. often from NASA, which is an association for international educators. Their figures suggest international students contributed somewhere around $44 billion to the U.S. economy just in the last academic year. So policies affecting these students have real economic consequences, too.
So wrapping this all up, it's really quite an extraordinary situation we've dug into here. You have this major university, Harvard, with this deep, decades-long history in government-approved international student programs.
Decades without issue, according to them.
Right. Then suddenly facing these incredibly broad, intrusive demands from the government tied to billions in funding, Harvard refuses, citing academic freedom.
And the government response, as Harvard describes it, is immediate and severe funding frozen, and then this unprecedented summary revocation of the visa programs that throws the lives of over 7,000 students into immediate jeopardy.
Followed by Harvard's immediate lawsuit alleging retaliation, viewpoint discrimination, and a complete disregard for established legal procedures, and the court stepping in, for now, with a temporary halt.
Yeah, our aim in this deep dive was really to cut through all the noise, the legal jargon in the complaint, the details of the regulations, the press releases, the social media stuff, and just lay out the core issues clearly for you. What are the central claims? What actions are alleged? And what's really at stake here?
And it really seems to boil down to this fundamental conflict, doesn't it? You've got a university fighting for its independence, its right to operate freely, its right to free expression.
Against a government that, according to the lawsuit, is attempting to exert significant ideological and operational control, apparently using these vital programs and funding streams as leverage.
It definitely leaves you with a provocative thought to mull over. If participation in essential government programs or access to federal funding can potentially become conditional on universities meeting broad ideological demands from the government of the day.
Or if long-established legal procedures designed specifically to ensure fairness and prevent arbitrary action can just be bypassed when politically convenient.
What does that mean for the future autonomy of universities, public and private, across the country? And who really gets to decide what happens inside their walls? It certainly raises some big questions.